start with this defamation case that you had against CNN that was overturned. I'm intrigued. Did you think that, what were the odds that you put on winning that case? You've done defamation cases in the past on behalf of clients.
Well, we always knew that we would lose at the district court level and that hopefully we would win at the appellate court or Supreme Court level. The judge who dismissed the trial admitted that the Supreme Court decision that required actual malice is unworkable. He condemned CNN for treating me wrongly, foolishly, and you could see he was very sympathetic. He praised me for bringing the case, but he said he was bound by the law. And so we're obviously going to be appealing and challenging the law and giving the Supreme Court an opportunity to reverse the actual malice standard. The irony is I was a law clerk on the Supreme Court at the time of New York Times versus Sullivan and helped draft Justice Goldberg's concurring opinion. But I've always had a problem with the actual malice requirement. It's impossible to prove. You have to get into people's minds. You know, what CNN did was, as the judge recognized, foolish and essentially outrageous.
So foolish and lazy.
Could be impeached if he committed crimes, lawless conduct, unlawful conduct, improper conduct, corrupt conduct. And CNN turned it on its head, doctored the tape, and said that a president can't be impeached even if he commits crimes. So the judge recognized essentially that I had been defamed, but we couldn't get inside the heads of the people. And he had to rule that there was insufficient evidence to say that they subjectively knew that they were wrong when they made these statements. So we're looking forward to the appeal.
So, and this is just to remind people, this was stemming from your defense of President Trump during the first impeachment trial.
That's
basically.
Right. It was during the question and answer period, I was asked whether a quid pro quo could result in impeachment. And I said, depends. If it's a lawful quid pro quo, no. If it's an unlawful or illegal quid pro quo, yes. And CNN doctored the tape and took up those words: unlawful, illegal, and corrupt.
You know, one thing that intrigues me about this case, and I want to ask about the Dominion lawsuit as well with Fox News,
Sure.
but you know, when you think about the bar, you think the bar is too high? I mean, especially as somebody who has worked on these cases, you know, there's the First Amendment rights, freedom of speech, and I think what is the appropriate bar in this country for defamation? Because to your point, actual malice has certainly been seen as a factor that has protected, you know, freedom of the press at the very least.
Well, first of all, I think the issue should be left to the jury because it's an assessment of credibility. You have people sitting there and saying, oh, I really thought he said a president can commit a crime. Well, you know, a jury's not going to believe that. But a judge says, well, if he said it, there's no evidence specifically to contradict it. So I would send the issue of actual malice, if it remains, always to a jury. Second, I would reduce the standards of actual malice from recklessness, reckless disregard for the truth to basically foolish disregard for the truth. And the judge found that what they did was foolish. But the line between foolish and reckless is the line between what's permissible and what's not permissible. And that kind of issue should always be left to a jury.